discussion group call for technical sovereignty. This is Introduction to Legal Research, and we're just going to be highlighting a few things this evening, and there's going to be a reference to what we were talking about last week and how to use the tools that we showed you last week. And there are things that I think a lot of us see in social media all the time and don't even really realize what we're looking at or how to examine what's being shown or cases that people are citing. To do a little bit of house cleaning, actually, right off the get here, Jeremy. For a long time, I've noticed on social media a lot of comments that people make regarding codes, statutes, the law, whatever you want to call it. And the argument that, they'll say, hey, you're not supposed to follow that. That's man's law. You're following Satan, or you're following the Vatican, or you're following the devil, or whatever. Right. But though, it's like, wait a second. They say you're only supposed to be following the Bible. All right. Well, I'm not sure if they know where all of these different public law statutes came from. But let's go back and let's take a look, actually, at what happened in Scripture. If you want to follow the Bible and pound the Bible on this issue, fine. We'll look at what the Bible says. And I would take you to 1 Samuel chapter 8. Excuse me. 1 Samuel chapter 8, Israel said that they wanted a king. They wanted a king that sat on a throne like all the other nations had. They want to be like everybody else. And Samuel was their leader. He was a priest at the time. And he went to the Lord and said, what am I supposed to do? And the Lord said, you know what? Don't worry. They've not rejected you. They're rejecting me. He said, and here's the thing. You go back and you let them know. I'll give them the king if that's what they want. But here's what's going to happen. This king is going to send your sons off to war. 2, he's going to take advantage of your daughters. They're going to be made to serve him. Point number 3 says, your land and your crops will be given to his servants. I think people should pay attention to that. Your land and crops will be given to the king's servants. Guess what that means? You're not even considered one of his servants. You're below that. What are you? You must be a slave. And then number 4, the Lord told Samuel, he will take a 10th. What's a 10th? It's a tax. He'll take a 10th of your seed and your vineyards. Well, guess what? That sounds awfully familiar to what's already been happening. That's been going on for centuries. And it was predicted. Samuel was told, tell the people that this is what's going to happen. This is what they're going to get. If they want to follow an earthly king and follow his laws, this is what's going to happen. And they said, we don't care. The people said, we don't care. That's what we want. Well, guess what? That's what we've got today, and that's what we're dealing with. And if you want to go back to the Art of War from Sun Tzu, written as late as 500 BC, 2,500 years ago. And what did it say in Sun Tzu? What did he say in the Art of War? He said that you are to know your opponent. Unfortunately, a lot of people stop there. But the whole statement that Sun Tzu said was, know your opponent and know yourself. And that second half is probably the most scariest thing for most people, is really getting to know yourself. You've got to know your strengths, your weaknesses, because what are you dealing with? You're dealing with a king that man has put there, and you're dealing with the laws that man has created. So guess what? You follow the 10 Commandments, bring that up in court all you want, whatever, not going to do you any good. All those laws are gone. The laws that matter right now are the laws that the king, that the people wanted, is in place now, and the laws that he is setting forward for everybody to follow. If you read further on in 1 Samuel chapter 8, the Lord also says, you know what? After you get all this, and you're going through turmoil, whatever, you're going to cry out to me. But in that day, the Lord will not hear your plea. Why? Because you chose to follow man instead of him. And that's the system that's running today. It's man's system. How are you doing tonight, Jeremy?
I'm doing okay. I'm looking at what you're saying here, and I'm thinking that I would have to say, yeah, you're right in a lot of aspects here, but at the same time, in some respects, I would have to respectfully dissent based on the fact that everything's been based on good moral character. A lot of these Ten Commandments have kind of been instilled in the law. You know what I mean? It's kind of hidden in there. You'll see that statutes and in general, if they're not constitutional, um, then they are, unconstitutional. It's like they have to protect your rights in order to, be constitutional. There is a lot of truth to the aspect that, in some respects, it seems like anarchy because people don't understand how to represent themselves and represent the issues. But these codes of law and the criminal laws that we see in play very much so reflect the laws that we see coming from the Bible. But what we also see is people perverting their offices. I mean, we have that in pretty much anything that we see in any profession. It can't just be, instilled to, this profession and this profession and this profession and not government. But I would never say that, it's been completely 100% corrupt. We've seen corrupt governments in the past that are very very corrupt. Then we've seen ones that have been successful, and I would have to say that King David's kingdom and King Solomon's kingdom was very successful. It's known as the Golden Age. They kind of created commerce to be able to do this beyond the world, and that came after that prophecy as well. So you've got to understand that, yeah, there is a right way of doing this stuff, but it's all going to be in truth and righteousness. And what I see is a lot of these positions of power were built to be there in truth and righteousness, but there's been people that have been perverting it, and that's whenever you get to the position that we see, um, trying to create world governments and stuff for that matter.
Well, and to rebut your dissent, because I don't really think it's a dissent, because I really agree with you. And that's because, what did Satan say he was going to do? He didn't
Right.
say he was going to become greater than God. He said he would be like God. And
There you
so
go.
that's what the system has done. But it couldn't come up with anything original on its own. So what did it do? It just mirrored everything that the creator had put in place. So it would
Yeah.
be like
A, ca-
God.
a counterfeit, and you see that a lot. Like you see Absalom before you see Solomon, and they're both of their names, almost meant the same thing. You see that there is an Enoch before there's another Enoch. You see Cain before you see Canaanites. You see a lot of this other stuff. You see the aspect of Lucifer in the book of Enoch, having a very interesting situation with the people, and teaching them a lot of things. And then would they have like a blood oath on top of the mountain, Mount Armin, and they when they taught all these the women that they took and had children with, they taught them a lot of things, and they taught them how to make swords, breastplates, mirrors, all this stuff. And they taught them a lot of interesting wisdom and knowledge and potions, all this stuff, Arca, and they taught them secrets which are in the heavens. This is an interesting thing because you see that he wanted to be God, and he's created this position to where he's misusing power. And what I'm finding is we're supposed to be recognizing that we're supposed to be sober, we're supposed to be vigilant because our adversary, the devil, roams around like a roaring lion. So I see all that, but what I also see is the education level. It says, "My people perish for lack of knowledge." It says, "Wisdom is better than rubies," and wisdom is better than weapons of war. We've seen that also stated that the pen is mightier than the sword. These are all things that we understand from history that are to be true, and I think that those are things that we can still see today. even in the legal profession, as such as law. And I think that a lot of people don't understand that law is just another way of being able to sell your presentation. It's just sales, but it's in a professional realm, and it's on your arguments. And that's all it is, really. And as long as you understand that, you should be able to openly debate in public areas to be able to beat your opponent. But you want to be able to understand who your opponent is as well. You want to see the training that they have. You want to see what you're prepared for. It's very important to study your opponent. If you don't do that, you're setting yourself up to fail. You don't know what you're getting into, and that's just not something you want to do. You shouldn't even ever be on the battlefield if you haven't studied who your enemy is, and because then you don't know what their weaknesses are. You don't know what any of that stuff is.
Exactly. You got to be able to find their Achilles heel. If you're planning on being successful, you've got to know their weaknesses. You got to know your enemy. And
Hmm.
so, a couple of arguments that we see posted around, I want to bring up this evening, and I posted links to them in the chat as well. And I'm just going to mention two of them. There's a whole list of them. They're actually in another article that I wrote on WordPress, which will be in the description box also on YouTube here. But one of these popular cases that you see shared around is the Flournoy versus Shreveport case.
Yeah.
Or should I say Flournoy v. Shreveport. I was noticing on somebody's website the other day where they were citing a whole bunch of cases that they were bringing forward. And the way that they had styled their cases was the verses, the VS, period. And
Mhm.
that's okay to use like in conversation or in writing back and forth. But if you're like writing like an official document for something, you just use the V period. It's the way it's supposed to be styled. So when I saw that they were doing their cases this way, their personal cases, I was like, gosh, that's just such a basic element that they obviously don't know. It really made you wonder how much else they really didn't know. But anyway, in this Flournoy v. Shreveport case, the quote that you see shared around says that statute is not law, which is another one of those legal fallacies. Because if you go into the citation of the case, if you read the holding in the case, the statement you're actually going to see in there does not say that statute is not law. It says an unconstitutional statute is not law. For some reason, when I see this get shared around, people conveniently leave out that word unconstitutional to lead people to think that all statutes are not law. When technically, if anybody knows where statutes come from, they would know that they are prima facie evidence of law. Those statutes come directly from the public law written by Congress, and Congress is the one that has the authority, the sole authority, to make laws. Do you want to
That's
refer to anything on that case? Yeah.
Well, basically, that case is based on there was a statute that was already deemed unconstitutional, and then they went and they made an argument saying that, hey, the statute was unconstitutional. You can't do this, and then the court agreed with them, and that's pretty much what that ruling is about. So we already know that unconstitutional statutes are not law, but going and claiming that all statutes are not law is absolutely ridiculous. Statutes have the force of law by the consent of the governed. That means that the people have enforced their civic duty to make those things become law, and that aspect is being overlooked. And the thing is the people that have been serving to elect the people elected to do these things. Certain things can be checked if they are unconstitutional. You'll have to make sure to understand it's not violating constitutional right, or it's not vague and all that kind of stuff. Or if it doesn't, if it applies wrong, because it causes encroachment. There's just all kinds of different angles. But the thing is you have to make these arguments to be able to challenge the statute or the constitutionality in the court system, and that kind of, it goes under heavy scrutiny, and to see if it actually is constitutional, and then they will rule. And if they rule on it, they'll tell you why it's constitutional, or if they can't find a reason to explain the reason why, they'll let you know as well. So I mean, there's a lot of that. I would have to say that that statute is totally being misquoted. I see it in it for a long time, and I have to say that myself, I almost believed. Actually, I did believe it. I believed that that was actually legitimate, and then I did the unfortunate mishaps of actually looking the case up and reading it, and got totally educated, and my ignorance was no longer there, defeating, my understanding. So I wasn't limited by what I knew. Now I understand fully what I'm looking at, and somebody challenged the statute beforehand. They went straight in and they said, "Hey, wait a second, this is unconstitutional." There you go. It's already been deemed. It's res judicata. What are you guys doing? That's the proper way to be able to understand this. But you guys got to understand, when you're reading your cases, make sure to brief your cases, because if you brief your cases, you'll be able to shortly, simply explain it. And the dicta is what you're trying to do. You're trying to make sure to simplify these cases for other people to read it in fast action in your documents, just so you can prove your points of what you're trying to say.
Yep. Yeah, you got to be able to brief it, which is, what we were essentially going over last week as well with the IRAC method, is knowing how to think, knowing what you're looking for. Now, at the same time, when you go and you see these cases and you look them up, just because you see, like, in the body of the case, the cases will be laid out when you look them up. It'll be laid out with, what the case facts are. Then you're going to have the body of it. You're going to have the defense. And then third, you're going to have the court decision, which will normally be followed up by the holding, which is the reason for the decision. When you're reading that, if you see things mentioned in the body of it, like in the defense, statements that are made, those statements are not part of the court decision. Those are just arguments that were being brought forward. Where you're really going to find what the case, what law is laid down, what common law is laid down within the case, is in the decision and in the holding.
Well, what you'll find from what I'm learning is you're finding a lot of, there's a little bit of back and forth. You've got the facts, and then you've got the argument that the defendant made, and then you've got the reason why they did it wrong, or the reason why they did it wrong or right. See, what I will tell you is, one of the cool things and fascinating things that you'll learn. You can learn from a lot of cases either way, if they won or lost, because whenever they lose, they always tell you what they did wrong. Those are so important to know what you did wrong, because that's the foundation of doing it right.
Yep. Well, the second case I wanted to bring up is a very popular one that you see shared around, probably one of the most popular ones, and it is the Rodriguez v. Ray Donovan case. And the statement that always accompanies that case is essentially the same as the last one that we mentioned. The citation they claim is that all codes, rules, and regulations are for government employees and are unconstitutional and lacking in due process. And if you go and the header always that I've always seen when this Donovan case is shared is it says, U.S. Supreme Court says, all right. Well, when you go into that case, number one, not only are you not going to find any of that wording that I just mentioned, regarding all codes, rules, regulations, are for employees and being unconstitutional because of a lack of due process. Not only are you not going to find that, but what you will find, if you look at the header of the case, is that case is from the 9th District Court of Appeals. It's not from the U.S. Supreme Court. So they've got all the elements totally wrong whenever I've seen that case shared around. And so, if they don't even know what court it's really even coming from, how well can you really believe what people are claiming about a court case? But you gotta love that Ray Donovan name, you know?
Yeah, that's hilarious. No, it's crazy because you've got to brief your cases, and you'll find out really really quick if you didn't do it right, and they'll attack that. That's going to be your weak point. And usually, I've been I don't know if this is like a theme or what it is, but it seems like there's a lot of people that are getting this stuff on the internet and just blindly putting it in their documents, and they're just setting themselves up to look like preposterous. And you got to understand right now, there's a theme going on. There's people that are trying to label people as pro se litigants that are trying to go in and defend themselves. They're trying to label you as sovereign citizens and try to claim that you think you're above the law and all that kind of stuff. Oh my gosh, that is so far from the truth. It should be recognized as more or less a pro se litigant moment, because the thing is we're trying to make it so people can understand that they need to defend themselves and stand up for themselves. What is it? Thomas Jefferson said the people themselves are the best depositors of the truth. That still stands true today, and I think that that's kind of the message that we're trying to do is teach people education and try to teach people to be able to use the system to benefit themselves, and make it so they're not being separated for their money. It serves their best interest.
You got it. You know, one of the other, I guess you could call it a legal fallacy that I see floating around out there is that you're constantly hearing people say, you know, you got to question jurisdiction. Yeah, question jurisdiction. And, you know, your appearance needs to be special. You need to make a special appearance. And I don't think anybody I've ever heard talk about this when they're stressing that it should be a special appearance, they ever tell you what a special appearance is for.
Right.
Because a special appearance is for primarily questioning personal jurisdiction and maybe a problem with service of process. But a special appearance is for a question of jurisdiction. Like I said, primarily personal. But people don't go into that. And so I see so many times that people will send me like cases and I'll read, you know, that they're appearing specially, da da da. And I never see any mention of a question regarding jurisdiction. And it's like, okay, they saw this idea online or on social media or whatever, and they ran with it, not even knowing what special appearance is for. I think Black's Law, maybe a second edition, touches on it. And it says that special appearance can only be or personal jurisdiction, rather, same thing, can only be used by the defendant if they're operating in propria persona, which is proper person. And it cannot be argued, according to Black's Law Dictionary, cannot be argued by an attorney because an attorney is an officer of the court, which that all makes sense when you think about it. The attorney's position is already bifurcated, you know. I found it interesting one time I was in a case and an attorney was making an argument about something and said, you know, he needed to converse with his defendant ahead of time before they went further down the path that the judge wanted to go on. And the judge said to him, well, sir, said, you do understand that your position here is bifurcated. And I think that judge, I'm sure that judge probably thought I had no clue what that word bifurcated meant. And when she said that to the attorney agreed. He said, yes, I do comprehend that. And what do? They continued down the path that the judge wanted to go on, because the judge pointed out that your position as an attorney is an allegiance to the court. And right now the court wants to do this, so go with it. And I don't know, maybe he had never been placed in that position before and didn't know how to overturn it. But anyway, I just found that kind of interesting.
Yeah, I mean, they are officers of the court, and if they were to truly be able to represent you, they would be able to go to jail for you. So there's a lot of truth to that.
Exactly. Well, these were just some brief things I want to touch on that you can do using the tools from last week as far as IRAC in a case, looking at the issue, the rule, the application, and the conclusion of it, because that's
Well,
what you need to
the
be looking at when you're even paying attention to a court case.
IRACing is basically based on the issues. You want to be able to identify the issues. You want to understand what everything is, the main points. You want to brief your cases so you understand how to argue your cases in your motions. That's going to be your best way to be able to create your legal standards, and to be able to recognize where you need to go. You're going to have to really understand the aspect of putting your standards of review in there, because if they do rule and they want to abuse discretion or whatever, you have discretionary review, you have abusive discretion, and you have an independent review. These are appellate reviews of the lower court's decision. You have these arguments in there asking them to make findings of facts and all that stuff on the issues, and then making the arguments, legal standards based on your brief cases. You might be able to get a ruling in your favor, but the thing is, you have to make sure to understand that in order to be able to properly write your motions. You want to do your IRACs and your memorandums. Your memorandums will cover basically the issues that you're trying to argue to make it so they can understand it. And usually your memorandum is made in support of your motion, and you want to make it so everything is 100%. It's just like it's supposed to be a key to support your motion. I mean, if I could stress that, but it's supposed to be written at the highest level of logic, in support of your motion, and it's supposed to be veridical on the topic, only talking one topic, all the way to the end to emphasize your point. Then your affidavit that you create, it should be able to support the law that you're trying to say at the same time, because you've already have all your factual standards in there. You want to make sure that your order is something that the judge would actually sign. Don't put anything in front of the judge that would embarrass you. The aspect of, if you want the judge to sign something and you can't word it, just ask him to grant it. Don't ask him to do some crazy, hypothetical, whatever, hyperbole, whatever. Make sure that it's something that he can agree with. And if just granting it is what you're requesting, then you save him a lot of time by writing the order. Um, those are just simple things of practice that I've learned from experience. I've just watched a lot of these guys, really, like, they try to make it so the judge has to work. You don't want him to work at all. You don't even really want him to think. You want him to go, oh yeah, that's totally right. And as long as you're getting them there, you're moving fast pace. I mean, there's these things that you can get to pick up tools. Like, they have these subtitle heading things from like Georgetown and all that kind of stuff. You can go and look up stuff and see how you should be writing your documents so they can be easily read and fast action. But you got to understand, when you're a pro se litigant, you don't want to expose yourself, and you want to make sure that you can kind of play dumb, and you want to act like you can understand things. And sometimes, you don't understand things, and you want to slow it down a little bit. So you put a whole bunch of motions on the table because you want discovery to find out what's going on. I would say that always try to keep them in discovery if you can't, if you don't feel confident about moving forward to trial. And sometimes you have to, because you ain't getting your exculpatory evidence, or you're not getting this discovery, or not getting that discovery. If you don't bring that stuff up and you race yourself into trial, you waive those objections. And that right there is pretty much just like, it would be called, in a way, it'd be like called suicide on the court, because you were like, you had a way to get out, but you threw it to the wolves. And then now you can't blame anybody except for yourself. And that's kind of what they say about it. You read all these motions about waiving your objections, You can do that whenever, say you're making an argument and you're arguing back and forth, and your opponent comes in and brings up 5 things. Now you see the 5 things that they brought up, but you only address 2 of those things. That means you waived 3 of your objections, and you can't bring them up back up now. And the judge rules in the favor of them because you waived those objections. Now you gave them an argument. You only have to waive one of your arguments sometimes to be able to give them an opening. And the A student always covers all of his issues. And I would say that those are things that you should probably understand in this game of writing, and it's very important to understand that. And I've learned that from failing over and over and over and over. And I'll have to say that being successful, you want to cover everything.
Yeah, and let me add to that as well. Because somebody commented on last week's video, and they're like, "Oh, IRAC is for legal rating," and it's like, okay, that tells me they didn't listen to the whole video, because that is exactly what I mentioned. It is for legal rating, but it's also a way of helping you learn how to think.
Yeah.
And that's what people need today more than anything, probably, is learning how to think. When you see people just automatically going and somebody hands them a mask at the door of a store and they go and they throw that mask on, you know that person has lost the ability to think. And
they're being told.
Yep,
Sure.
they just do what they're told.
Mm-hmm.
All right, Jeremy, do you have anything you wanted to add tonight?
Well, all I can say is you got to work hard for success. It's never going to come easy. And even if you want to believe that it is, it's just not. And this game is really, really hard. It challenges some of the best of the people in the country. Some of the most brilliant minds have become lawyers, but at the same time, some of the most brilliant minds have also beaten good lawyers, and they weren't lawyers. We have a lot of things that are in our favor, but at the same time, I would have to say that if we educate enough people and if we get people on the right path and start employing their civic duty, we can put the country right on the right track to be able to save the country. But right now, we've got to wake up a lot of people, man. It's just scary right now.
Yeah, you've got it right there. Well, like Sun Tzu said, and like I try and remind people every week, learn who you really are, where you're really from, and where you're really at, because we've been deceived on those things. And I agree, Jeremy, if we can get enough people learning how to think and comprehending these basic elements, the ship could be turned around. It could be righted. So share this video with people, friends. Thanks, Jeremy.
All right, brother. God bless.
God bless. Have a good night, guys.